presentation. Hi all, thank you for participating, and thank you to our speakers for giving us the floor. And it will be a very interesting conversation today, mostly focusing on the AI Act. Just a very brief presentation of the EVOLVE2CARE project for those of you who might not be familiar with it. Basically, we are focusing on transitional care. Transitional care is the safe transfer from one setting and environment to the other. And the goal is to bridge the gap between a lot of stakeholders, such as providers, services, and different settings. However, we wanted to see within this project if there could be a link for transitional care between living labs and innovators and innovation in general. And this is actually what we did. We used living labs as the research and innovation enabler, as they are able to provide a lot of facilities and resources on demand. They are open, they are transparent, and they are also an environment where a lot of different stakeholders can co-create, they can share their ideas, and it is basically a co-located environment where we can have transfer of ideas safely and with many more with a way of interdisciplinarity. So what we did was we used a platform that was it is actually from the European Network of Living Labs. It's called AXELAB, and in there the innovator can upload a project, and then subsequently the living lab can bid on the certain project, and the innovator can accept the offer, and then they can start testing. Here, actually, what we did was we had an open call, and we provided 10 vouchers of 5,000 euros to external companies so that they can use the Living Lab services to test their products and validate their ideas. We had in total 44 projects, and we received bids from 32 Living Labs, and the final matched Living Labs and companies were 18, and from those we gave the voucher to the 10 companies after evaluation. The most requested services were the usability testing, were the small-scale real-life density, concept feasibility and impact assessment, and of course, co-creation sessions as services that could be provided for the living labs. And what we realized was the fact that living labs, which might not have been known as a tool for a lot of companies, they are able to validate the human-centered digital health solutions. We can overcome a lot of barriers that a lot of the companies found in the past, such as regulatory or business model or user validation hurdles. And then we can perform crucial real-world testing through the living lab so that we can accelerate market readiness. However, we also produced a KPI framework, both for the validation of the living labs as well as the innovators. And we had an overall impact assessment KPI repository that was for the overall impact assessment and validation of the EVOLVE2CARE project. And of course, there are 2 training sessions that are uploaded in the annual Living Labbers Academy, and they are available to all. The first training session was mostly focused for the Living Labs, and the other one was mostly focused for innovators and researchers. And by using the QR code, you can access them below. There were a series of a lot of relevant stakeholders, and you can participate in them online so that the knowledge is ongoing and never ending, let's say. That was a very brief presentation of the project. So now I would like to give the word back to Sharon so that she can start with the presentation.
Thank you, Anastasia. I'm just going to share my presentation now, if that's okay with you. So I'm Sharon Srirap. I'm a lawyer by profession, and I'm part of the Malta IT Law Association team. And we are also one of the participants to the DataPACT project. We mostly support the work package leads, which is K11 in University of Leuven and the DataPACT project. And we have done this in relation to various legislation, significantly, obviously, those that mostly affect the AI dynamic and space, and that would be the AI Act, GDPR, Data Act, and the Data Governance Act as well. Today, I'd like to touch upon, because the time is quite limited, to cover a lot of the implications, that AI systems might have when it comes to legislation. Well, we will focus on some, I'd like to focus at least on some salient points, especially within, let's say, the healthcare sector, and just a few take-home, messages in this space, as well as what we have been doing within the DataPACT project, and how we are seeing these laws play an important part in compliance in this project as well. So I am more than happy and glad to take any questions as I'm going along. I like to do so and tackle them during the presentation, but also at the end of it as well. So to start off the conversation, at the moment, we are experiencing quite a lot of tech laws that are being, or new laws updates. There's a lot of seismic shifts that are happening in the space. Their implications on new technology are vast and wide, and there is quite a lot of discussion about good governance and compliance. And so a project such as DataPACT, as I'll be explaining a bit later on, it's quite significant. So as you well know, data is the very foundation. It is the essential building block, right, of artificial intelligence systems, and particularly in the healthcare sector, there's quite a lot of data that is processed, and this data is usually categorized as very sensitive, and it's treated as a special category or a sensitive category within at least within the laws that we look at on a day-to-day basis. So there's quite a vast, there's quite a lot when it comes to processing of personal data. There's vast volumes that are being processed. This can be in a structured or also in an unstructured way. It can be personal, it can be non-personal, but in brief, without data, AI systems would lack the necessary input to learn, to make predictions, and also to generate their outputs. So we see data being, let's say, laced in AI systems, in the lifetime of these AI systems, from the very beginning when it comes to input and training, to the very last life cycle of these systems with their output. Now, given this intrinsic link of data and law, it's not just law, actually. There's a lot of ethics that play a very important part when it comes to making sure that what is being processed and the data itself is regular. So you get laws such as the GDPR, which they are very important parts to regulating the actual data that's processed. And you get the EU AI Act, which indirectly regulates data through the, let's say, design of these AI systems, and for them to be compliant by design as well. And generally ethics, which would then also ensure another added layer of fair and safe and a regulated safe space for the processing of personal data as well. Now, laws are mostly complementary to each other. So just because the GDPR would apply, it doesn't mean that the AI Act doesn't. So we also have to see the dynamic of the interplay of these laws, because sometimes they are complementary, but there are also times when they are also working against each other. So it's also nice to have a look at laws and how they play out when it comes to compliance together. But this slide basically gives you an idea on where we stand today. These are all the digital laws that have been enacted, some of them which are in the pipeline, and others that are still being discussed. For instance, the Quantum Act, which is the next step that the EU would like to deal with. But the EU AI Act is very much now regulation that is part of sort of that body. GDPR has been there since 2018, so that's something that it's the usual suspect that we usually also have to look at. Now, besides all these digital laws that we tech lawyers have to deal with on a day-to-day basis, we also need to add another layer there. So you have sectoral legislation that we would need to look at. For instance, you get the medical devices regulations that you would need to look at if you are looking at AI systems also within that context. But beyond that, we also need to be sensitive to national nuances. So if there are any directives here, those would be transposed into national laws, and there could be different interpretations that are attributed by each and every member state. So that's something that when it comes to regulation, we also, let's say, take in consideration as well. Part of our task that we had within the DataPACT project was to conduct a market requirements survey to feel the pulse or understand the pulse of entities at the moment, undertakings at the moment, what they have been doing in terms of their taking up of these AI systems, how they have been approaching, let's say, regulation, whether compliance is part of that plan or whether this is something that they add on at the very, let's say, aftermath of taking up these AI systems. And you can take this market requirement survey. It's still very much open, and this would be very helpful for us to also understand more and more where undertakings are or institutions or educational establishments are lying within this space. Part of the questions were very, let's say, informative, and we asked direct questions such as, are you involved into the AI space? What is your operation? Whether you think that you are going to invest in the space further. And I think the majority, as you can see here, it shows a reality where the internal operations very much rely on the basis now of also AI systems, and the take-up, or at least the future plan, would be for undertakings and businesses to go in this direction, more and more in this investment and direction. So we're seeing more of a take-up. So I suppose there is even more significance now in trying to understand where law lies before with these AI systems before you actually take these systems on board. Also because there are various laws, as you can see over here, that are directly affecting AI systems. So you get the DGA, as we mentioned, also the usual suspect being the general GDPR, General Data Protection Regulation. But now we have added on the EU AI Act as well in that list. And this is something that would also need to be taken in consideration. And it is very difficult for me to go through all, because of clearly the time constraints, to go through all the obligations within, let's say, AI systems, particularly the interplay in the healthcare sector. But I'll touch on some interesting observations that we have made so far within compliance and how laws have had a real impact on such systems. So if you have a look at the letter of the law, so what laws actually provide, for instance, when you get the GDPR, Article 5 and 6, which are two extremely important. I call them the commandments of this particular law, because they have They're extremely important when it comes to processing activities. So any operator, any data controller that is going to start processing, whether you're in the healthcare sector, aviation sector, retail section, whatever that may be, a data controller is an entity that processes personal data and determines the purposes and means of processing. So it is literally in the driving seat of what happens with this personal data. Article 5 and 6 regulate this very purpose. So when it comes to purpose limitation, the data must be collected in a specific way, it must be explicit, it must be legitimate. And there are other principles that must be respected. For instance, data minimization, that only data that is adequate, that is relevant, that is limited, must be processed here. But if you think of AI systems, right, and what they can actually do, these principles seem to challenge the very notion of of how AI systems work, given that they rely on such large-scale data sets and on the repurposing of data and general purpose models. And also within the healthcare sector, where we see quite a lot of information that is being processed, sometimes also incidentally and not purposefully. And therefore, there is obviously some legal tension over here, where the GDPR targets constraint use, but AI systems thrive on expansive, let's say, flexible data sets. So the question here really is, can GDPR concepts that we have seen before, these purpose limitation concept and data minimization concepts that I just mentioned, can they be respected by AI systems in the first place? And the answer to that is, whilst a lot is still left for future interpretation, because we are we're still seeing case law that is emerging within the sector. We're still seeing opinions and let's say adjudicators, that courts and arbitral bodies that are looking at within the space. So there's still a lot left to future interpretation, but what we can say for sure is that clearly one must specify the purpose for training or deploying of an AI system or an AI model. So you need to really try to understand, sort of what the context and how this would align. For instance, with Article 10 of the AI Act, which clearly defines purposes, for instance, for high-risk AI training. That is how we see the interplay, or one instance how we see the interplay of GDPR and the AI Act. It is ideal to use synthetic or anonymized data wherever possible, especially when it is within the context of sensitive personal data, such as in the healthcare system. The EU AI Act dedicates a specific clause for data and data governance obligations. So it's good to keep that in mind, especially when you are processing within the context of a high-risk AI system, which makes the use of techniques involving, let's say, training of AI models with data, and in respect to which there are certain, let's say, governance obligations that must be mapped out before such data sets are processed in the first place. So we see the AI Act in this space more or less aligned and complementary to the GDPR. And finally, it is also important, especially if you're in the context of special categories of personal data, such as healthcare, that you would carry out the necessary privacy by design and default. And one of the ways of respecting this principle would be by conducting data protection in impact assessments. These are just a few examples that I can think of or mention for good compliance, and also how the EU AI Act and the GDPR work, let's say, in tandem over here. But obviously there's quite a lot more, and I would just like to go back then to Article 6. This is because, sort of these list for every processing activity, you need to have a lawful basis of processing. So you need contract, consent, a legitimate interest, these would need to back up as much as possible those processing activities. If you are in a special category, such as healthcare and health law data, then this needs to be backed up by a further purpose, which is provided under Article 9 of the GDPR. Also, it's if you're in the space of AI systems, it would be very, very interesting to have a look at Article 22 of the GDPR. This is complemented again very well by the AI Act, where there is automated decision making, especially of data. And so there is the automatic processing of personal data. And this requires, which is generally prohibited, but if allowed, then it requires a human in the loop. And there are human in the loop provisions also under the AI Act. So that's something also to keep in mind. In the last few minutes, well, I provided some key points again from a compliance perspective. So it's very, very nice to understand what kind of data you're processing. And excuse me, I'm getting a call. It's nice to understand what data is being processed and what under what basis you are processing within the main provisions under both the GDPR and the EU AI Act, because they work so well together. Try to understand what data and systems you have in place and what kind of data they would be processing and what kind of laws as a result are applicable. It is not very easy to keep track of laws because they are constantly changing as well. For instance, we have seen the digital omnibus package, which has overhauled some of the GDPR as well as the AI Act provisions very recently. So that's something to keep in mind as well. And also to make sure that you have the compliance by design and default. A few words on the DataPACT project, at least insofar as the legal work is concerned. So this is a project where the target is to ensure compliance by design for data, AI operation, and AI pipelines as well. The idea is to guarantee compliance at the very outset of these systems and how they are designed. We've got 7 brilliant use cases that are testing, sort of the knowledge repository that we are coming up with, and they are very, very interesting because they cover quite a few domains, incidentally also healthcare. So that is one of the areas how we are looking into legal considerations to best serve primarily these use cases, but also later on the industry in general. And there are some tools which will feed off the, let's say, legal artifacts and work that, not all of them, right? But some of them will also feed off of the legal work that we are taking on as, let's say, project participants together with the work package lead over here. Some of the work that we've covered so far is that we've come up with a really nice repository of current laws and legislation that apply directly in the space to these tools, methodologies, and also to particularly the use cases. We've also mapped out some national transpositions of certain laws, especially where there are directives that would need to be then transposed into national legislation. And we've built a nice list of the national laws that would also need to be considered together with the EU laws, such as regulations that apply the minute that they are rolled out by the EU Commission to all member states. We've come up also with some guidance, not just to the participants of the project, but also in particular to the use cases, as well as later on, this will be guidance and opinions on these laws and how they should apply. And also we need to regularly update them because of the legislative advancements that are happening at the moment, and some flowcharts as well that will feed into the tools, looking at decision making on how GDPR applies and AI Act. For the time being, we've covered the GDPR, but that would also the work is also anticipated to continue on the AI Act, the GMDA at a later stage. And finally, as legal support in this project, we've also built a repository of questions and answers, Q&As, and these are tools, again, that cover the legislation as it stands today, and they will be used to train the tools and also for tool input. Not just, but because they are they've been designed in a way that a participant or a use case would also be able to tap into these Q&As to determine a particular, let's say, legislative provision and how that legislative provision would apply in the context, again, of GDPR, AI Act, and processing generally of data. So this is the work that we've done so far within the project, and we have a year and a half to go, so that's we anticipate that there's more to come when it comes to legal support for these tools and methodologies. And I think that sums up from my end, Anastasia. I'm happy to take any questions now if there are any, but otherwise I leave the discussion or hand the discussion back to you.
Thank you very much, Sarah. We thought about leaving all the questions for the end and like have a Q&A session for all of them. So we will get back to you with any possible questions in the end. Thank you for the presentation. It was very interesting because it touches upon a topic that a lot of people might not be very familiar with, or we might have like an overview of all the legal stuff and the legal perspective. Thank you very much. And we'll now pass the word to Paolo so that he can continue with his presentation.
Thank you all. I'll be in a way continuing the presentation in some way from following up on what Sharon has been saying. And I will be presenting basically the tools that we have developed and our approach to automate compliance. So it's not in no way a substitution for a lawyer, but it is meant to provide, to ease the burden of dealing with all these rules, provide more transparency, and as we will see, improve this whole process in a complementary way. So we all know that AI needs data, and data, as we've seen, needs policies. There are a lot of rules that apply, and so Sharon has already explained a lot about the regulatory requirements, so AI Act, GDPR, and so on. But when we talk about policies, we also consider a lot of other types, anything essentially that can create rules over how data should be processed, like organizational policies internal to some organization, like data governance policies, or rules that only apply to specific entities that came into a certain contractual arrangement, like data sharing agreements. So when I use the word policies in this presentation, it can cover any of these, it can apply to any of these type of legal texts. And yeah, as I mentioned, the point is to assist with processing, with automating some elements of compliance. So specifically how to create some of these policies, how to agree on them, then how to connect these rules with consent. A lot of these regulations are about the presence of personal data, and how to evaluate the policies, so basically how to use them in practice. And at the core of everything we do, there is the Open Digital Rights Language, ODRL, that some of you probably already know. And this is not a new thing, has existed for over 20 years, has now reached W3C recommendations. So it's now a web standard. And it is also the de facto standard for machine readable usage policies. So it's already used a lot. It's not just a research project. There's a growing adoption in data spaces, in AI systems, and currently it's in version 2.2. So if you were familiar with ODRL, it might have changed since older versions. Now it's more expressive. It is not, it won't be able to fully represent textual, complete legal text, but the point is not to completely substitute legal text written in plain language, but to encode and automate parts of it. So the core component of ODRL, if you think about what actually ODRL is, it defines rules. So an ODRL policy is a set of rules. And the most basic rules are permissions, prohibitions, and obligations that, from my understanding, match pretty well to standard legal terms. Like permission would be when there is a clause where an entity may do something, prohibition, they shall not do something, and obligation, they have to do something. So these are the core types of rules. But then in ODRL 2.2, rules can relate to each other. We can also have we can represent more complex interaction between rules, like duties. For example, before doing an action, like maybe sharing data, you might have the duty to anonymize the data. So this would be a rule about anonymizing that relates to a duty about sharing. You may have consequences. So what if you have not fulfilled your duty? What should you do to restore compliance? Remedies, it's a similar thing if you violated the prohibition. So using these rule types, ODRL tries to reconstruct the policy or elements of a legal text that then a machine can understand and in some way automate. To give you an idea of what a rule actually looks like, essentially it contains a number of components, usually an assigner, an assignee, an action, an asset, and constraints and refinements. It doesn't necessarily need to have all of them. Here we have an example. Dr. Smith permits the cardiology team to analyze MRI log data if the patient consent is active and the duty of anonymizing data has been performed. So these elements, so ODRL would understand these elements so that, for example, the entity that needs to that can follow this permission is the cardiology team, and that the action they can do is analyzing, but they can only do it if the constraints are met. In this case, it's a constraint about consent, but ODRL allows very complex constraints to be connected, basically whole logical expression. You could have things like if the patient is above the age of 18 and they live in a particular country and something else or something else. If this whole expression is valid, then this rule will apply. And then someone in this case will be able to exercise a permission, but it could be a prohibition, an obligation. They would all look basically, they would all have these building blocks. And so we have this ODRL language, but actually one of the innovations that we've brought through the DataPACT project is that actually we have developed a formal semantics model. So despite the about 20 years of usage, ODRL has been used in very different ways and interpreted in very different ways. There was a lot of ambiguity. But we have defined the first comprehensive mathematical semantics. What this means is that we have an exact mathematical way to determine, based on a policy and something that has happened, whether that event that has happened is compliant or not. So this mathematical approach basically removes ambiguity, and obviously then you would need to be careful about constructing a policy because it does this exact reasoning. But this is very important for automation because then, without requiring a human to check nuances, it can make decision in an efficient, exact way. Obviously, in a real system, you would want to double check the answers that is exact approach is giving you, but it will help you understand whether something can be compliant or non-compliant and give you very useful inputs. When we think about using a policy, we usually talk about a couple of possible options. One is the monitoring and auditing. So you can imagine, and this is a small example of an ODRL evaluation engine that we've actually built, which is called Oval. So you can input events, could be a stream of events, could be logs of, for example, electronic health records being accessed, lab results being produced, data transfer, anything, technically even not necessarily related to data, but any action that can be logged can be fed into this evaluator. And that then, based on the policy, can tell us essentially, are these events compliant or non-compliant with the policies? And of course, if a violation has been flagged, it's you may still want to check with a real with a human, with a legal expert, but it will help you a lot if you have a lot of data coming through to highlight the problematic cases, because we have now this way to automatically check the policy on the data. And this approach that we've built based on the semantic is very, very efficient, so it can handle large throughput of events and does not need to record previous events, can stores a minimal amount of information to being able to just being able to look ahead and still give you these exact, precise answers. Another very related mode of use of a policy is in access control. So if someone wants access to a data, and then we use this engine to tell us whether we should grant or not the access request based on what the access is, so what they want to do with the data, what data are we talking about. So based on the policy, our system can generate an exact answer whether it should be allowed or not. Then, of course, could be double checked, but it will be able to make this decision automatically. So it's not just about evaluating compliance or not, or access control. There are more things that an ODRL engine can do with policies, like validating them if they're structurally sound. It can compare them. This is very important when we want to see if a policy is stricter or not than another policy. Very useful in if we want to do data sharing. If someone requests data and they want to use it according to a stricter policy than the one that is being offered by a data owner, then we can find a match and automatically establish that, yes, this data can be passed on to the person requesting it. We can also generate synthetic policies and events for benchmarking, for testing. And I'll try to move quickly as I think I'm running a little bit out of time, but essentially there's a whole ecosystem of tools that also covers how policies come to be. So we have a policy editor. I mentioned ODRL is a machine processable language, so it's written in a technical format, but with an editor with menus, drop-down menus, and clicking on things. This can make it much easier. We have negotiations, so people can agree, for example, on policies for data sharing. We have a contract service that can produce contracts based on ODRL, and we can transform ODRL into something that is understandable in natural language, so bridging the gap between machine readable and human readable. And I'll just briefly touch on the fact that in order to express this concept, we need the right vocabulary. So we are reusing the data privacy vocabulary, or DPV, that it's very related to GDPR, contains information, for example, about personal data, special category data, and with the help of our legal experts in DataPACT, we're looking at also extending this, because it does not cover the whole of GDPR, but we can extend this vocabulary. And for any domain-specific use that one may have our policies. We can, of course, use specific vocabulary with what we call domain-specific ontologies. So this approach is very customizable to any domain, basically. And we can, an integral part of this is requesting consent. So we have a consent manager tool that creates basically ODRL-based consent requests. So when someone provides consent, we can translate that into ODRL rules, and it can be factored in the policies that require consent, essentially. So yeah, I went very quickly over this as yeah, I don't want to run out of time too much, but yeah, later I'll be happy to take any questions you might have if you're interested in any of these tools and how they work to automate elements of compliance. Yeah, thank you very much.
Thank you very much, Paolo. It was very interesting because I feel like ODRL is a very hot topic and something that is, I think it has already started to be implemented in a lot of processes. So thank you very much. I think we can proceed to questions for both of our speakers. So are there any questions from the audience?
Actually, hello from me. I'm Kostadina Tibita. Thank you for your presentation, both of you, and for the organization of the webinar. I have a question about the ODRL and how it can connect, like if there are any challenges or how you see it being connected with some requirements coming from the AI Act. Or in general, what are the main challenges that you see organizations are facing when choosing like one of those many tools that are available about making their tools like AI ethical and compliant? If you have any insights on that.
Yeah, that's a very good question. I would say that, yeah, there are definitely challenges because with ODRL, we're trying to make something that is that reflects important elements of a policy. So, for example, the prohibitions, obligations, permissions, but there's a lot more nuance in a legal text, as I'm sure the legal experts here could confirm. So we at the moment we're trying to look at where elements that can be automated, where maybe if we don't automate it, there's a lot of legal burden. So you're looking more, for example, the duty to have consent or to anonymize data or to use data for only specific purposes. But in terms of the tools, the ODRL is quite extendable. It's a quite general language. So we are trying to adapt it to as many users as possible. But there are elements that, for example, cannot be automated automatically because, as you've seen from the presentation, when it comes to evaluating a policy, see if we are compliant or not, we need to evaluate on something. And so in what I've shown, we are evaluating on a log of events, or we are evaluating it on an access request to maybe use some data. Outside of this context, is if you don't have information about something that has happened, or if there information about some purpose that has not been disclosed in the access request, then we cannot automate that part. So yeah, we'll be able to do everything out of the box, but you can extend it. I don't know if it answers.
No, I'm trying to understand. So everything helps at this moment. So thank you. Thanks a lot.
Thank you. Are there any other questions? I wanted to ask one for Sharon. Regarding the AI Act implementation within organizations, I think that's something that has started, not currently, but it has not been going on for a lot of years, right? So how are the organizations actually adapting to all of those legal frameworks? Because I know that regulatory and legal frameworks, the more we add to the organization, sometimes they might frown or like, kind of make it a little bit more difficult for them. How do you feel like they are adapting to all of this?
Yes, I mean, there is a huge debate that's always going on when it comes to these new regulations and technologies, right? The debate of innovation versus regulation. It's an endless debate. We can go on and on about it, which comes first, or which should come second, or which should be regulated in parallel. But the sentiment, at least that we get also from clients, when we're advising, is that as usually happens when you have these kind of heavy-handed regulations coming out, when you get part of the AI Act is already in place. So it's already applying. We are not within, let's say, a grace period still. So for instance, when it comes to prohibitory systems that are prohibited, AI systems that are prohibited, that part of the AI Act already applies. For instance, there are systems that are either, let's say, I mean, on a very high level, dangerous or unethical or illegal, then that would fall within a certain class risk category, and therefore it is already applicable. So I would definitely suggest for any business or undertaking or anyone that is not just producing these systems, developing the system, but also those entities that are deploying such systems as well, because as a parenthesis, just because you deploy a system, so just because you take up a system off the shelf or from another AI system producer, doesn't make you exempt from the AI Act. You still very much fall within those parameters. So you have that responsibility to try to determine that whatever you're adopting is also very much aligned with the law. But the sentiment that I am seeing at the moment is that undertakings are still trying to digest and understand what the very implications of this AI Act. GDPR, we've seen it there, so we've seen it in practice. We have quite a lot of guidance there, so that seems to be more familiar territory. But how actually data and GDPR is going to complement the AI Act, that is something that we still need to see, and how personal data and the implications of personal data within these AI systems, that's again something that's still being tested out. And there's a lot of guidance that's still, I'm sure that still we still need to see it there. So just on a very sort of high level basis, I feel that there is awareness about compliance rules, especially the AI Act compliance rules, but I feel that we are still at testing stage and we are still trying to determine what the implications are for our businesses, not just as manufacturers, producers of these systems, but also as deployers of these systems as well. And quite frankly, I feel the pulse and the sentiment and the concern that a lot of startups, creators and businesses in this space are having, for the simple fact that there has been a lot of changes and also changing of goalposts when it comes to timelines and implementations. The legal professionals have had difficulty also keeping up with this, let alone whoever is actually implementing the stuff. So I mean, as I've shared within the slide, I think the very first step is to do the data mapping, to understand actually what lies within your repositories, how you are using it, and how you are lacing through these AI systems, just to start doing a bit of a gap analysis to understand where you lie with data, how you intend to processing or how you are processing it, and then bring in the laws, especially the new legislation such as the EU AI Act, where it necessitates, compliance assessments and new governance mapping, etc., that would require an added layer of governance within undertakings as well. So, I mean, that is, I feel, the sentiment that we are seeing at the moment.
Thank you very much to the both of you for today's webinar. We were able to touch upon issues that might have been known or to the general audience, but it was very nice to have two perspectives, one more technical and one mostly focused on the legal parts. So again, thank you, Sharon and Paolo, for your presentations. They have been extremely helpful, and we look forward to seeing you under different frameworks as well. Again, thank you for everyone who participated. And yeah, see you soon, hopefully.
Thank you. Bye-bye.
Thank you. Good day.
Thank
Bye.
you.
Bye.
Bye.